Hi guys, this is Mr. Tan, and today we're looking at the English legal system. So, when we look at the English legal system, we have to look at the different sources of law. But the question really is, what is law? If you think about law, law is the system of rules created by the state, concerned with governing the conduct of citizens and people and laying down standards to which we all need to conform. So, these rules are enforced by the courts and the legal system in our society. The law provides for remedies, sanctions, punishments, and regulates behavior. The main function is to ensure the functioning of society. So, when we think about the English legal system itself, then, the English legal system is based on common law as opposed to civil law. And the difference between common law as opposed to civil law, like countries like Germany and France who use civil law, is that the laws are judge-made rules set out in case law, whereas in civil law these are set out in a codified set of rules. The role of judges is to interpret the rules and then to apply these. So here we can see the difference between the two. When we think about the different sources of law in the English legal system, then we have primary legislation, secondary legislation, case law, and EU law. And primary legislation, this is known as statutes, and is the legislation enacted by Parliament. Secondary legislation, this is known as delegated legislation. So this is made by bodies under the authority of Parliament. The delegated legislation takes the form of laws, statutory instruments, and orders in councils. And then we have case law, and this is also referred to, as mentioned before, as judges made law, and it refers to the decisions made by the court and its judgments. And then we have EU law. The decision to join the EU means that in some instances the UK has passed the power to Europe, but now we've got Brexit and now we've taken back power, but nevertheless we're still going to be reliant in some instances and in some industries in terms of abiding by EU legislation, but that then would be modified into our legislation in the UK within the Houses of Parliament. And within the Houses of Parliament, Parliament has superiority. So Parliament is the supreme lawmaking body in the country, and it's the supreme law, as Parliament is sovereign. So legislation passed by Parliament is superior to all other sources of law. So in any times of conflict between case law and legislation, the legislation will always take precedent over case law because of the superiority of Parliament. So when we think about legislation, we also think about statutes, and a statute is a document containing the laws made by Parliament. Statutes is also referred to as Acts of Parliament or legislation. They're created directly by Parliament, and once they've been passed by Parliament and they've gone through the process, then they are unimpeachable. And there are different types of kind of legislation, and these can include public bills, private bills, hybrid bills, and private members bills, which we're going to go into later. But we have to understand that how does a bill develop? Well, firstly, the proposals are made in Parliament, and then there is a period of consultation, and then there is a white paper that is produced, and this is followed by a green paper, then a draft bill prepared, and then the draft bill goes back through the passage to become legislation on the books. And this passage will include going for a first reading, a second reading, a committee stage, a report stage, a third reading, and then going back to the next house, and then go for the same process: the first reading, the second reading, committee stage, report stage, third reading, and then going back for any final amendments to the first house, and then once that has been passed, then going on to the Queen for her royal assent. So when looking at the types of bills, we have public bills. So public bills change the law as it applies to the general population. And the most common types of bills introduced by Parliament, government ministers propose the majority of public bills. Those put forward by other MPs or lords are known as private members' bills, but we're going to come onto that later. So really, these are government ministers putting forward public bills. What do we mean by private bills? Private bills, are usually promoted by organizations like local authorities or private companies to give themselves powers beyond or in conflict with the general law. Private bills only change law as it applies to specific individuals or organizations rather than to the general public. So groups or individuals potentially affected by the changes can petition Parliament against the proposed bill and present their objections to a committee of MPs and Lords, at the committee stage. So again, we can see how these bills are different from the public bills. If we look at the private members' bills, well, private members' bills are public bills introduced by MPs and Lords who are not government ministers. As with public bills, their purpose is to change law as it applies to the general population. A minority of public bills become law, but by creating the publicity around an issue that may affect the legislation indirectly. And then we have hybrid bills. Now, hybrid bills, mix the characteristics of both public and private bills. The changes to the law proposed in a hybrid bill would affect the general public, but would also have a significant impact for, specific individuals or groups. So if we look at the example of the Channel Tunnel, which was an example of a hybrid bill, and so a hybrid bill taking some aspects of the Channel Tunnel bills passed in the 1970s and 80s that affected the southeast to the UK, and then Crossrail bill with the new east-west link through central London passed in 2008. But now, taking parts of those bills, we can see a hybrid bill with the high-speed rail West Midlands to Crewe bill 2017-2019, which has been passed through Parliament. So we can see that different bills may come together which have already gone through different stages, so they won't need to be as time consuming as possible. And if we think about hybrid bills as well, we're really thinking about these bills in terms of Brexit as well. Even if we're thinking about Brexit, then we're saying to ourselves, well, we've already got the legislation and these bills have already gone through certain stages, then they won't necessarily need to go through the same stages for specific legislation, which would need to be changed because now we're out of the EU, but we won't need to go through the whole process because of hybrid bills, because certain stages have already gone through at different in terms of the first stage, second stage, committee stage, report stage, and so on and so forth. When we talk about the different houses in Parliament, we are talking about the House of Commons and the House of Lords. And in the House of Commons there are 650 elected members, and in the House of Lords there are 825 elected members. So the bill must go through both houses and all the different stages as explained previously. Now, a typical example of case law can be seen with the landmark case of Donahue versus Stevenson 1932. And in Donahue versus Stevenson, this established the principle of negligence that we see today. And again, we can see with this principle all the way back in 1932, this has established a precedent for similar circumstances that will happen with regards to negligence. So we are going to be progressing on to the next video now, which will be focusing on the court system and the court structure. So thank you today for Mr. Tan on the cases and sources of law.